versus Nathan Lucas. Case number Nathan Daniel Lucas. Case numbers SP 106-84961, SP 1111617, counts 1, 2, and 3, SP 11116371, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not an etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce.
We open with a classic sovereign citizen performance in Judge Perkins' courtroom. The defendant insists on calling himself a living man, as if that's some kind of magic phrase that will dissolve all of his charges. Judge Perkins, clearly used to this nonsense, tries to keep it moving, but ends up chuckling at the linguistic gymnastics. When asked if he wants a lawyer or even a driver's license, Lucas refuses outright. He tries to plead in the form of a demurrer about jurisdiction while confusing the court with obscure phrasing. The judge, unfazed, sets a pretrial date. It's a textbook example of sovereign citizen tactics failing instantly. Even as Lucas insists he won't enter a plea, the judge calmly does it for him. It's all perfectly polite, but you can see the exhaustion in the court. The date is locked in with the patient, but resigned final goodbye. And you can tell Judge Perkins is probably counting the days October 21st when this will all happen again.
He brought up in my pleadings and filed with a court.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with a court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Hannah here. I'll enter a not guilty plea on your behalf, sir. I'll give you a $0 bond, and I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir?
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that will be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m. All right?
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right. Well, I'm entering in for you. All right. Have a good day, sir.
We shift to Judge Gay's courtroom, where familiar sovereign citizen is back because naturally he failed to show up last time. The judge dryly notes there's now an absconding charge confirming that ignoring the court doesn't work. Defense want to continue the hearing due to the new charges, which is fine by the court. They set the next date, showing the court system's stubborn patience with these antics. Then the defense lawyer asks to reinstate bond, arguing the client is self-employed with work lined up. It's a last-ditch appeal to pity mentioning winter months and feeding his family. The judge listens carefully but doesn't seem impressed. The defense emphasizes his now hired real counsel, admitting he used to listen to bad advice, but claims that's over now. It's an attempt at damage control for a defendant who refused to even show up before.
File 23-748FH. And who do we have from the people on this file?
That would be me.
Prosecutors,
One county prosecutors.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So, Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. So,
I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time?
yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his.
Geyer responds with firm skepticism. He doesn't buy the claim that ignoring legal obligations was simply taking bad advice. He describes it as willfully doing something foolish. He is not about to reward someone for brazenly ignoring the court. He even notes a defendant used to reject court mail by scribbling on it in red ink, quoting irrelevant federal codes and pretending he could just not accept legal jurisdiction. The judge highlights the absurdity. You can't commit crimes and then claim you don't agree to the court's contract. It's like a grown-up child telling their parents they don't consent to bedtime. The judge also points out this wasn't just a minor slip it was a deliberate plan to avoid accountability. He sees no reason to reinstate bond for someone, so determined to avoid court. Next voice. Next voice. The prosecutor backs up the judge's concerns. They acknowledge the defendant finally got real legal help, but stress that history matters. This isn't about punishing him for hiring a lawyer, but about protecting the integrity of the system. The man actively refused to appear, leading to bond forfeit and an absconding charge. That's serious business. The judge also notes that even though the underlying charge isn't the worst felony on the docket, it still demands respect for the court authority. The bottom line is you don't get to opt out of your criminal case by refusing to accept mail or scribbling fake contract refusals. The judge lays out the consequence. Bond will stay revoked until the case is resolved. It's a clear message that reality doesn't bend for sovereign citizens.
He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To understand, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you. Ms. Gitters, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
The judge doesn't miss the chance to give a bit of real-world advice. He explains that if you want to provide for your family, ignoring court orders is exactly the wrong move. The message is blunt but fair. Choosing to buy into anti-government nonsense can ruin your ability to work and care for loved ones. The courtroom becomes a teaching moment for anyone tempted by these fringe ideas. There's a certain grim humor in watching the judge calmly demolish the notion that I don't consent is a valid legal defense. At the end of the day, courts exist to enforce the law. Defendants can't just opt out because it's inconvenient. It's a reminder that the law applies equally to everyone, even those convinced they are too clever for it.
Acknowledge even the authority of the court and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear. And
Now, we head to Georgia where things get even more bizarre. We meet a defendant in a wheelchair who is apparently facing charges for fleeing and eluding police. The judge points out the obvious contradiction, listing multiple charges while dismissing some duplicate counts. The man listens, but then interrupts, trying to say he doesn't consent to the proceedings. The judge keeps it professional but firm, clarifying that this isn't a trial, but an initial hearing to read charges and set bond. There's no time for sovereign citizen monologues. The defendant's refusal to accept a public defender suggests he'll hire his own lawyer, but he keeps contradicting himself about wanting help. It's clear he's rehearsed a script without understanding how any of this actually works.
All right. Mr. Whitlock, you have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary.
The judge systematically goes through the charges: aggravated assault, obstruction, theft by taking, and more. Some charges are dismissed as duplicates, but others remain serious felonies. The defendant protests, claiming he can explain everything and that the officers even told him it would be thrown out. He insists the police were just being unfair and planting extra charges on him. The judge tries to rein him in, reminding him this isn't a place for testimony or cross-examination. He'll have his chance at a proper hearing. But the defendant keeps pushing, telling the judge that he knows the system better than anyone while contradicting himself repeatedly. It's a strange mix of defiance and cluelessness that's painfully common in these sovereign citizen encounters. Next voice. Next voice. He also tries to make jurisdictional arguments that don't hold water. He questions which county should have the case, arguing it's Fulton County's problem, not Clayton. The judge explains carefully that the aggravated assault happened in College Park and clarifies the warrant jurisdiction. But the defendant doesn't seem interested in understanding. He keeps talking over the judge, insisting officers know him and buy food from him, as if that proves innocence. The entire exchange shows a man desperate to talk himself out of.